This is Ask Todd on the Financial Exchange Radio Network. If you have an existing estate plan or are in the market for one, Todd Lutsky is here to answer your questions and help you plan for later life. Ask Todd is presented by Cushing & Dolan, serving Massachusetts and New England for more than 35 years, helping families with estate and tax planning, Medicaid planning, and probate law. Visit CushingDolan.com. Now, here's Todd Lutsky.
Every Wednesday, we're joined by Todd Lutsky from Cushing & Dolan for a weekly segment of Ask Todd. For any of you out there who have any estate planning questions, whether it's regarding estate taxes, Medicaid, probate avoidance, give our studio line a call at 888-205-2263. Again, that number for any of your questions out there, 888-205-2263. Todd, how we doing today?
I am never better, and you?
Doing quite well. Todd, a question for you. For folks out there, one of the basic tackling blocks for an estate plan oftentimes is avoiding probate. And I was wondering if you could just kind of give the listeners a sense for what types of assets may be probatable and the impact it would have on their heirs if their assets were to go to probate because they had not done a proper estate plan.
Yeah, and I think I'm going to answer that in line with the guide that we're giving away this month, which is Back to the Basics, because in that guide, one of the things it talks about a lot is the basic documents, in addition to the trust that's involved in that particular guide. But it really spends the time we need on basic documents like a will, a healthcare proxy, a power of attorney, a living will, a HIPAA form. These are basic docs that don't get as much attention. I say that because probate and the will go hand in hand. And since your question is on probate, I can tell you first and foremost that folks that do a will, please don't think that that's an estate plan. They think it is. They come in, they say, I've got my estate planning all done. I got a will. Well, it's better than nothing, I can certainly tell you. The will at least will ensure your assets go where you want them to go and how and when they're going to get there. However, I like to tell people that a will's a won't, because what it won't do is it won't avoid probate, which I'm going to get to. I know I'm getting there, but it won't avoid probate. It also won't reduce your estate tax. So if you're married and you leave assets to each other in a simple will, you didn't do anything to reduce your estate tax liability. So not a probate avoidance deal and not an estate tax savings. And if one of your goals is to protect assets from the cost of long-term care, also a will won't do that. So those are generally things that are used to make up an entire estate plan, and the will misses all of them. Now, the big thing it misses is it's the only document that has to be filed at the probate court. And when you get into probate, you now are looking at about a year-long process, number one. Number two, it's costly, right? You got to file things, and it's not even the filing fees so much, folks, as it is likely you're going to hire a lawyer, and it's the legal fees that you're dealing with for the next year when you go through the process. And it actually appoints an executor or a personal representative who, by the way, has no power until you're actually appointed. So please don't think just because you're listed that you're automatically the PR. You've got to go through filing a petition at the court, notifying all the heirs at law so they have an opportunity to object to you being appointed. And then finally, when you get a return date to the court, now you're appointed. And only after you're appointed can you run to that bank or to that brokerage account. And with the petition or the appointment from the court in one hand and the death certificate in the other, will you be able to finally access that money or sell a piece of property or move real estate. So it doesn't happen right away. So that's a good 60 to 90 days just to do that. Right. And then, of course, there's inventories and accountings and on we go, folks. But I hope that gives you a little flavor of why you don't want to be there.
I've seen it with clients that I've dealt with firsthand going through that probate process, like you mentioned, just a real administrative burden. So it's important to try your best to avoid that. We're going to take a quick break here, but if you have any questions for Todd Lutsky here from Cushing & Dolan, give our studio line a call at 888-205-2263. Again, anything in the estate planning realm, any questions you may have, give our studio line a call, 888-205-2263. When we come back from break, your questions next with Todd Lutsky.
Ask Todd with Todd Lutsky every Wednesday at 10:30, only here on the Financial Exchange Radio Network. You're listening to Ask Todd with Todd Lutsky on the Financial Exchange Radio Network.
Coming back from break here, we're here with Todd Lutsky from Cushy & Dolan. For any of your estate planning questions, give us a call at 888-205-2263. We're going to go to our first caller, John in Waterbury, Connecticut. You're on with Todd Lutsky.
Hi. Does Connecticut accept handwritten wills?
Handwritten wills. Well, I don't think it's the handwriting that matters. I think what matters is that it has the testamentary language that you need in it. Like, it needs to have in the very beginning language that says, I hereby revoke all former wills, right? All prior wills. So that needs to be in there. Whether that is typed or whether you hand wrote it, I don't believe matters. Now, I'm going to give you that as sort of with a grain of salt, because I don't know off the top of my head. I'm just going to give you what I think the legal requirements of a will are. I've never heard that a will has to be typed in order for it to be valid. I mean, think about wills that existed before we had typewriters. I mean, they did. They were handwritten and they worked. So I think you just need to make sure that the will has the testamentary language. That's number one. Number two, probably is going to need at least 2 witnesses and likely a notary. So you got to have at the end the notary and the 2 witnesses. So that has to be in there. So I think if you can get those kinds of things, and usually there's a self-proving affidavit language at the end as well. So as long as you've got that requirement, or any other Connecticut, because folks, I say this, every state might have a few different rules as to what makes up a valid will in that state. So please look to your state. But I do think as long as you have those requirements that make a will, then it's valid. Whether it's typed or handwritten, I don't think is the determining factor for making it a valid will. Great question, though, and it does go back to this guide, which is back to the basics, right? It does talk about all of the basic documents in detail: wills, healthcare proxies, powers of attorney, HIPAA forms, living wills. It also gives you an idea about how to pick a lawyer. It talks about what to think about when you're doing your estate plan, how much you're worth, valuing your assets, family dynamics, all things that you need to think about. And then it's basically my legal recommendation to a made-up family with made-up family dynamics and assets. And then I give the description as to exactly how to accomplish all of their estate planning needs, culminating with an irrevocable trust. So get the guide. It'll help you get started at a bare minimum. And who knows, when you put your family situation into this fact pattern, maybe this is actually a recommendation for you. Call and get the guide, 866-848-5699 or legalexchangeshow.com. Back to the basics, 866-848-5699 or legalexchangeshow.com.
We're going to go to our second caller here, Mike in Boston. You are on with Todd Lutsky.
How you doing, Todd? My name is Mike. I'm in Boston. My parents put together a real estate portfolio, which they put into irrevocable trusts. My father passed away, and now it's my mom, my brother, and I. Uh-huh. And surprise, surprise, my brother and I do not get along in any way. And we're inheriting these properties in the trust. And we're both concerned about how the business, the real estate portfolio is run after my mom passes. And so I'm concerned about, him. He's concerned about me. Is it important? Is my best option to put into place what I'm calling a non-biased trustee member to oversee the trust and kind of manage the funds, and then the importance of getting an operating agreement to kind of hold each other accountable?
So let me ask you this: are all these rental properties in an LLC?
They're currently not, but the firm that we've hired is pushing to get them into LLCs.
So I would think an LLC is a good idea, and I think the shares of and maybe multiple LLCs, I don't mean to say one, and then all of the shares themselves should be owned in these irrevocable trusts if that's what they've chosen. Irrevocable, I don't know if that's the right way to go or not, but it doesn't matter because you're concerned more about what happens when they both pass, and the trust, of course, at that point will be irrevocable. I wouldn't jump to the conclusion that you need to get an independent trustee right away. The most important thing is that you guys decide, and you're going to have to talk to each other to decide what you want to do. You got to read the document to see, does it say divide the property and pay it out to you kids and walk away? Does it say hold it in trust for your lives, in discretionary trust for your lives, and then you got to run and manage the company? I don't know. You need to read the document to see what it says. If it says divide it, pay it out, walk away, our trusts usually have language that says, look, property sold unless you all want it. Well, if you both don't want them, then it's going to be sold. And if one wants it and one doesn't, then the one who wants it can buy out the one who doesn't at fair market value. So again, fighting or not, you're going to be able to at least get past that, walk away with what you want, right? Maybe they don't want to be. Maybe one brother says, I just want the dough. Okay, well, you have to arrange to have it purchased and bought out. So I would look to try to not cause any more fighting. Just say, look, from a selfish standpoint, we're both working towards the same goal. You get what you're supposed to get, I get what I'm supposed to get, and we don't have to work together. If we want to work together, yeah, I would have it in an LLC, and you guys should be managers of your own buildings, and sit back and collect rent and just say, hey, we're just going to not be friendly, but we're just going to be, business partners. And money will come in and half will go to each of you, and that'll be the end of it. So I don't think there's a separate agreement you can have that says you're not going to fight. So that isn't going to work. I think you just need to work through it and look at what the document says first and foremost and take it from there. But I do like the fact that they've done some planning. So I hope that helps a little.
We're going to go to our last caller here. Mary in Waltham, you're on with Todd Lutsky.
Hello. My other phone is ringing. I hope it doesn't disturb you yet. I'm calling actually on my brother's part. He lives with his wife, but they don't get along, and 2 of their 3 adult sons live with them. But he wants to have a separate will so that, if he passes first, the house could be possibly split so that the wife doesn't get the whole asset. He wants some to go to the wife and the 3 sons, and the house be sold, because he said when the sons eventually inherit it, they are not good with money, and they would probably lose the house. So is there a way he can do a separate will when there's a house involved?
So if they're married still, and it sounds like they are married, correct?
Right. Yes.
So you can't technically disinherit your spouse. I mean, there's always a forced heirship that allows them to get some amount. Now, as long as you provide an amount equal to the amount they would get under the forced share, it's probably going to be okay. So do we do separate wills? Well, you always do separate wills when you're married. One for husband, one for wife. I think what they need is way more than a will. I think they need a trust. And I think the trust needs to be designed, to take care of the spouse. But by the same token, as you said, maybe, not just give it to her if that's the case. And therefore provide for, and I assume these are their own kids. It's not a second marriage, right?
Yes.
Right. So they're each going to want to take care of their kids anyway. So this will provide for it. And I probably would have language in the trust, again, not just a will, but a trust that not only protects it from potential nursing home claims and taxes, but that it could hold it in trust for these children who might not be great with money, as you said. And if need be, the trustees could always sell the house, the money could go in, and then the money could be used to take care of these children with discretionary distributions for their needs, their health, their education, welfare, support, so that it stretches out the money a little bit so that it can be used to better their life rather than just, dump it in their hands, and then that could cause way more harm than good. So I think they're going to need to do a little bit more than separate wills. I think they should sit with a lawyer and learn how a trust can really take care of both of them, and they don't need to really be angry with each other when they're doing this estate plan, because the common goal is the kids here.
Absolutely. Todd, thanks so much for taking time with us this week. Happy early birthday to you.
Oh, thank you. Always a pleasure.
This has been Ask Todd on the Financial Exchange Radio Network. Ask Todd with Todd Lutsky has been presented by Cushing & Dolan, serving Massachusetts and New England for more than 30 years, helping families with estate and tax planning, Medicaid planning, and probate law. Call 800-393-4001 or visit CushingDolan.com. The views expressed in this segment are solely those of Cushing & Dolan. Armstrong Advisory does not provide any legal or tax advice. Please consult with your legal or tax advisor on such matters. Cushing & Armstrong do not endorse each other and are not affiliated.